Welcome back to Lippincott Talk. My name is Josiah Lippincott. I am your host. Today I want to talk about birthright citizenship and the decision that was just set down by the Supreme Court in Trump v. Barbara. The court affirmed the existence of birthright citizenship for illegal immigrants and temporary visitors. This was an outcome that was expected by most political commentators, especially after we saw the transcripts that came out from the oral arguments. For myself, I predicted wrongly that the Supreme Court would rule in favor of Trump. The court did not do so. I take accountability. I was wrong. My gut instincts were off. Okay. At the end of the day, though, I don't think this decision is the end of the world. I think there are many ways forward. I want to talk about them here today. What I want to argue here today is that the core political issue of sovereignty, of what it means to be a country, a people, a nation, a union, is absolutely central to understanding where we need to go next. We need to get right on the core political principles. And the questions of law are secondary. It is not to say they're unimportant. I think the arguments over what American citizenship law meant at the time of the founding, in the antebellum period, what it meant after the Civil War, in the 14th Amendment itself, are important. Those are important questions. I agree with Clarence Thomas's dissent, and I agree with Samuel Alito. I think they're correct about the meaning of American history and about American law. I do not think, under the 14th Amendment, illegal immigrants and temporary visitors the children of those immigrants should be given citizenship. I don't think that accords with what the founders of the 14th Amendment wanted. I don't think it comports with American history. But I also want to say this issue in American life has never been as clear as it needs to be. I have done a good deal of digging on what the law meant at the time, what the principles were. And what I will say is, it is fair to say that this issue is complicated. It was complicated in the early American regime. There were often different states had slightly different ways of conceiving of who was and was not a citizen, or there are different categories of how you became a citizen, different requirements, different legal traditions. And it is true that at times the common law birthright standard, what we call jus soli, or the right of the soil, or the law of the soil, sometimes did have legal meaning in early American law. And the very reference to birth that's made in the 14th Amendment, I think, is a problem. Again, this is complicated. It's all these are some fine distinctions that are going on here. And again, I agree with with Trump's argument, with the government's argument, with the dissent made by Thomas. But again, the bigger point I'm trying to make here is the core question about political principle is even more important. It is more important than questions about the law and the tradition. I believe that if you are at the point of arguing about dependent clauses and their meaning, and you hang your whole legal arguments on grammatical constructions and arcane court cases and probate law from the early American founding, you're already losing in some sense. That doesn't mean there's no value to doing that kind of research and making those arguments. Again, that's not what I'm saying. My point is, the core questions, the essential element that we have to deal with is a question of principle. And it really supersedes history, the history of the American regime. It is, and I think this is in part true, the founders had good principles. And those principles have animated the American regime from its founding. They're relevant today. They explain core elements of who we are as a people. It is also the case that policy made at the time of the founding onward has not always reflected the full weight, import, or logical conclusions of our original principles. It doesn't mean the founding was wrong. It doesn't mean I reject what they said. Rather, I think it shows the need for clarification, for concise thinking on what those principles meant then, what they mean now. So my concern is, first of all, not historical. I am not fundamentally a lawyer or a historian. Those, to me, are secondary fields underneath political thought, political philosophy, political science, knowing things about what it means to have a political regime, what it means to live together, law, right, justice. Those are the questions I am concerned with, always and everywhere. And the historical and legal questions are secondary. Doesn't mean they're unimportant. It just means you have to put them in the proper place. And what I think has happened in the conservative movement, official establishment conservatism, is it has elevated questions of the law and history to the tier of the standard and has deprecated questions of principle and political right. And what I want to do is push us back to those core questions and those core questions of sovereignty. I think the biggest reason that, Trump lost this case, all of those things said, the reason the government lost this case, I believe, is because the arguments they were making were ultimately not compelling enough to really drive the point home, to build a consensus among the American people about what citizenship means. The government's case hinged upon the meaning of the word domicile and the meaning of where one is domiciled in American law in regards to citizenship. And that is when you have that kind of decision, when a big policy choice, a big change in American life hinges on something like the meaning of the word domicile, I think you're at a massive disadvantage. And it doesn't mean the government's lawyers were wrong. It doesn't mean Trump was wrong to make that executive order. It just means it's really hard to drive major political changes when you're trying to make really complicated, esoteric, arcane legal arguments. And I think that was the leading reason that the government failed. And part of that is the weight of tradition, the weight of confusion and ossification that has been present in American citizenship law came to bite Trump badly in this case. And again, it's a wonderful thing that Trump even brought it here. We would not be here were it not for Trump's decision to press the birthright citizenship issue. And it was opening the Overton window. But again, I want to make an honest analysis of why I think we didn't succeed, why Trump didn't succeed, why the country has preserved and really in some ways entrenched the institution of birthright citizenship. So this case really hinged on the 14th Amendment. I can pull up that text right here. Actually, I think it's always good to read the thing in itself. Here, let me pull it up. And this is the key statement. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So that statement right there, all persons born or naturalized and subject to the jurisdiction thereof. So those are the question in this case was, what does it mean to be subject to the jurisdiction of the United States, right? So I think the argument made by Chief Justice Roberts is not correct. I think he ignores, and I don't think his response to Thomas's dissent was particularly compelling. I think Thomas is the better of him when it comes to American history and the meaning of the principles behind the act. I don't think the founders of the 14th Amendment imagined that they were giving automatic citizenship to the children of foreigners and sojourners who were present in the United States illegally or temporarily. I don't think they thought that. At the same time, I think it is a problem that the 14th Amendment itself mentions birth and naturalization. The use of those words shows the problem. And let me explain. And those of you who've listened before may kind of know where I'm going with this argument, but I'll try and flesh this out. I don't think citizenship is dependent on birth. I don't think that's consistent with the founding principles. Samuel Alito, in his dissent, made that clear. He's the only one to mention the consent of the governed as being the foundational element of the American regime in this decision. And I think that's right. And birth is not a matter of consent. You don't get to choose where you're born or to whom you're born. But the argument of the founders is that you need to consent to be ruled by a government. And so consent is an active voluntary choice. That means it cannot be made by children because they don't have the power to consent. They're not formed enough. They're not reasonable enough in order to contract and make decisions for themselves. So not only does an infant not choose where they're born, but that infant has no ability to sign or make agreements. A child does not understand the future, much less how to make agreements that transcend the present. That's just not how their minds work. They require to develop. So the argument that I have made and will continue to make, and what I'm going to say here today again, is that the core element is consent. It has to be consent, right? America rejects the feudal tradition. We reject the idea of subjectship. We are not, the very idea of citizenship transferred through where you're born is inconsistent with the idea and principles of the consent of the governed. And by the same token, the idea of citizenship through what's called jus sanguinis, or through the right of the blood, is also not right. The right of descent is not the standard. Mere parental, whoever your parents are, doesn't determine citizenship either. That is perhaps the most radical thing that I have said here today. And it's probably where I stand the most outside of the contemporary debate over citizenship. I have not seen really anyone make this argument in full. And even I'm still working on developing and fleshing out what this will look like in practice. But I'm taking my bearings by the founding as well. I think part of the problem in this case is that there is this common law tradition of jus soli, or the right of the soil, or the law of the soil, where being born on territory determines where you owe allegiance. And that common law principle was transferred in part and in different places in American law after the Revolution. It was certainly not the dominant standard, and the idea of consent was embodied in a number of citizenship laws and statutes at the time of the founding. But you have this common law tradition that also has this place in American law prior to the Civil War and then even after it. So what I want to do is just to show that that is a problem that we need to rectify in our thinking. We need to go to the foundation of things and we need to clear the ground of the historical questions, the legal questions, the positive law, and we need to build on the firm foundation of logical principle. That's what I want to encourage conservatives and members of the right to do going forward. I think it's not going to be that helpful to fight these questions of arcane legal meaning. I don't think we lost on that today. There's some political choices going forward, but I really want to highlight, before we even talk about how to go about reversing this, we need to talk about what the end state should be. And I don't think the end state should just be preventing birthright citizenship for illegal immigrants. That would be good. It is a step on the way in the right direction. But the bigger question, the more fundamental question, is what is government for, and who is a member? How do you know? And for me, the answer to that question can be found in the idea of the social compact and made explicit and conscious. I do not think tacit consent is a useful or good standard for understanding who a citizen is. And it has been used. That tacit consent standard was used in part at the time of the founding and has been used ever since much more prominently, and I think that's been bad for us. I think tacit consent occludes the fundamental issues. It covers over what the core problems are and how to think through them. And so, from my perspective, you should always confront the core question. You should do so directly. And the question here is, who deserves to rule another? And do you owe allegiance and obligation merely by being born under a law somewhere, or being born on territory that a government controls? And I answer no. I think the choice needs to be made explicit and conscious. And I am taking that idea that idea was serious at the time of the founding. And so I want to zero in on those examples, which I really didn't see, insofar as I read through the decision from the Supreme Court, I really didn't see much focus on the idea of oaths or the early test acts in the states right after they declared independence 250 years ago this week. And I want to talk about that a little bit here today, because I think that helps show what it is I'm talking about. Hopefully will help clarify that in the minds of my listeners. And also hopefully you'll learn something that no one else is going to be talking about. And it's that the value proposition. You come listen here and I will autistically go find things that most will not. So there you go. You're ahead of the curve if you're here. So let me review, right? If I were a teacher in a classroom, this is a moment where I'd pause and ask if there were any questions, right? Do people understand what I'm saying, right? Am I being clear enough? Always a good question. In the absence of that, I will just simply say there was the idea of explicit consent at the time of the founding. We can find examples of explicit consent, especially in the loyalty oaths and test acts, the tests that were common in many of the colonies at the time of the Revolution. These acts establish explicit conscious consent as the standard of membership in those political regimes. Because citizenship at the time of the founding depended under the Constitution on how states understood citizenship, these loyalty and test acts are useful for thinking through how the founders understood the consent of the governed. The problem, as I see it, is that this standard, the idea of explicit consent, though it was present at the time of the founding and important, did not become the decisive standard for the whole country. So what happened? There was a natural tendency or a powerful tendency to return to the ideas of the older English common law with its view that where you were born determined citizenship and allegiance, that should be the foundation of citizenship. The fact that the 14th Amendment itself discusses birth is a problem. It is a problem because birth and consent do not go together. Birth is not a matter of choice. And so I do not think it can be the standard for membership in a regime rooted in the consent of the governed. But even the word naturalization comes from the Latin word for birth, natus, birth. And so naturalization is to become like someone born on the soil. And again, I just don't think that is itself a good standard for thinking through where citizenship and allegiance come from. In my view, the proper standard is that a parent takes an oath of allegiance, they become an American citizen, they have a child. That child, while they're in their minority, while they're young and they're growing up and they're dependent, they receive benefits as if they receive benefits from their parents' citizenship during the time of their youth. When they reach the age of majority, it is then at that moment that person should have the ability to become an American citizen by explicitly choosing to adopt the rights and duties of citizenship at that moment. So they receive benefits and they give something up in that moment when they decide, and they have to decide when they come of age. And when that happens, then they become a citizen of their own volition. And if they don't choose that pathway, then they could live as a resident alien. They could go find another country to move to. But the point is, the idea is that if you want to enjoy the rights of citizenship, and you could define those broadly, I think there's a number of, I think this is worth clarifying, but an obvious one would be the right to vote and serve on juries. If you want to have that right, then you need to take on obligation as well. And the biggest obligation is the duty to defend a regime from violence in a moment of war. And connected to that, to pay taxation in return for those benefits of protection that are the core purpose of government. So from my standpoint, from my understanding of the founders' principles, from my understanding of what is best conducive to human happiness, the answer is protection, and from protection of person and property. Let's be very clear, protection of person and property allows for the pursuit of happiness, the pursuit of higher life. That's the core purpose of government. When you consent to join a political regime, you take on duties, a willingness to defend the regime in time of danger, to pay for its upkeep of the services it provides, to exercise the right to vote, and to exercise the right to adjudicate decisions of justice in a court of law. So all of these things are connected in my mind, and I don't think that a child, merely by being born, owes allegiance simply because of being born somewhere. Now, they might, because they partake of their parents' citizenship, there are obligations that might extend to them, right? And when you live on someone's territory, even if you're not a member of that regime, you owe a basic allegiance to the laws, a kind of, you're a guest. and the laws apply to you, or the sovereign power has every right to enforce its laws against you and to expel you if you don't comply with them, and also to punish you if you violate the law. So the bigger question here is, what about children? Because they're in the state where they might be born into a regime, but they have never been given a chance to consent to it. So how do you think about what that process looks like? In American history thus far, tacit consent, or even, which often looks like birthright citizenship, has defined how the children of citizens, of American citizens born on American soil, come to be understood as Americans. And I think this standard then has kind of exploded outward to where it encompasses the children of legal migrants, the children of temporary visitors, and the children of illegal immigrants. I think all of this gets very confused. I think it's all unclear. And that, again, is why I think the explicit consent standard is better. Okay. I said I would talk about these loyalty oaths and test acts at the time of the founding. I think these give a good example of what it is that I'm thinking when I talk about explicit consent. So, and I'll read the whole thing here. It's maybe 200, 300 words, but I have every faith in you, my audience, that you can listen and understand what I'm going to say here. But I'm going to read the text of the Rhode Island Test Act from 1776. I think it is clarifying. So here's this text. This is from the Revolution, from 1776. Be it enacted by this General Assembly and by the authority thereof, it is enacted that no male person of the age of 21 years, being an inhabitant or resident in this state, shall prefer a petition to this General Assembly for setting aside any judgment or court, or staying any execution, or shall commence any suit, action, bill, or plaint before any court of record in the state, unless he shall previously sign the declaration or test prescribed by an act entitled, an act empowering the members of the upper and lower houses of assembly to tender to such of the inhabitants of this colony as are hereinafter mentioned a declaration or test for subscription. And that in case the General Assembly or court before which the same shall be brought or instituted shall receive information that the person presenting or commencing the same hath not subscribed the said test or declaration, such petition, suit, action, bill, or plaint shall be ex officio dismissed unless a proper certificate of such persons having subscribed said declaration or test shall be procured, or he shall there, if personally present, subscribe the said declaration or test. And be it further enacted by the authority aforesaid, that no person in this state shall have the liberty of voting in any town meeting in this state, in the choice of officers, nor in any other question, unless he shall have previously subscribed the said declaration or test. I'll end it right there. Okay, that's, again, written in the early American language. It's very officious, and is often difficult for our modern ears. But what that's saying right there is that in order to vote in Rhode Island at the time of the founding, every male above the age of 21 years needed to, if he wanted to enjoy the rights of appealing to the legislature or voting in town meetings, he needed to take a loyalty oath and test to determine that he could receive those rights of citizenship and enact them, right? And by the way, this was the idea of loyalty oaths was not unique to Rhode Island. I found an instance from the state of North Carolina and the state of Pennsylvania. I won't read them here, but again, these states provided for that there was a need for oaths of allegiance to be taken, and he received certain rights by taking those oaths, right? So, in North Carolina, it's just very important that individuals and for the state that you determine who is loyal and who is not. The easiest way is to make them state out loud and take an oath indicating where their loyalty really lies. So I think you see that principle, the idea of explicit consent, was present at the time of the founding. It was not so expansive as a doctrine that it came to define American citizenship everywhere and always, but it was certainly important enough at that time that you got acts like this, and there's a real argument for it under the principles of the founding, the one that I've alluded to here before. The idea of explicit consent as the basis of government was embodied in these loyalty oaths. The idea of expatriation, the idea that you could leave the United States and give up your citizenship, that too was present at the time of the founding. Largely applied to loyalists often, but it was possible to renounce your membership in the political community of the colonies and retain your citizenship in Britain. And many Americans chose that path. They chose not to be Americans. They chose to abandon their old allegiance to those colonial governments in favor of maintaining their citizenship as Englishmen. So, again, I don't see much discussion of the idea of explicit consent as it occurred at the time of the founding. And there are a number of reasons why that is likely the case. Again, lawyers really like clear legal precedent in court cases. So laws passed by colonial legislatures at the time of the founding, they're less likely to pay attention to those cases than in precedent that happened after the Constitution or in state courts. Also, the idea of explicit consent is very difficult for us to consider now. We are very much inside of a view of citizenship that frames ourselves as subjects. It's really how Americans think of themselves now. We pay taxes, and that's just the way it is. And so if the government wastes that money and gives it to Somali fraudsters or gives it to wealth redistribution schemes so that elderly pensioners can receive that money instead, Americans are not used to the idea of asserting their rights and of demanding that a connection be made between what they pay and what they receive in return. We don't tend to think of government in those terms. And again, this is, I think, a kind of spiritual rot that's developed over time. That as Americans, we have really come to see ourselves not fundamentally as free men, but rather as subjects of the state. And this, I think, is a process that is accelerated in the progressive era from about 1899 onward. And I think the effect on our national consciousness is bad. I think there's an intrinsic connection between mass migration today and the loss of the principles of the consent of the governed. Once you see immigration as something that doesn't require consent, then it becomes easy to simply flood the country. When you see government not as something that owes you something in return, but rather as an institution that simply has the right to your allegiance and your money and your resources, and that can just make rules for your life as it pleases, then you've ceased to see yourself as a member of a political community, as a citizen, and you see yourself as a subject. I think you also see this kind of decline present in the abandonment of jury trials as the foundation of our justice system. Everything today goes through the court system and lawyers and process and procedure. The moment of sovereign decision made by the jury is being steadily bracketed outside of our thinking about law. You see this in the way that legislatures like Congress and even state legislatures really don't pass laws at all. Instead, their focus is on, TikTok and grifting and insider trading and holding hearings. But the idea that members of Congress would vote on legislation that's crucially important to our lives has really gone away. We don't see we don't see acts of legislation now. The whole system, the procedures are designed to prevent those kinds of decisions from being made. We've lost the idea of the consent of the governed. We've lost the idea that protection and allegiance are reciprocal, that they are a matter of choice. We've lost a sense of what it means to be an American. And of course, once you do that, then of course all manner of crazy things are going to happen. Everything from COVID lockdowns to regulatory agencies talking about how much water belongs in a toilet bowl, to the question of whether, just opening our borders to the third world and making all of these people citizens. All of these things become possible when we lose sight of the core fundamental principle. What can we do going forward? Let me close here. There's a number of options available. I think one option going forward is, Trump can appoint new justices to the Supreme Court, make a litmus test whether or not they would be willing to repeal birthright citizenship. We could enforce ideological discipline on justices appointed by Republican presidents going forward, much the way the Democrats have done in the past in regards to Roe v. Wade. That could be a new standard. It could be effective. It depends in a great deal on the future and who Trump and his successor are able to appoint. Very important, whoever gets appointed has the ability to appoint justices that will rule the right way. It's a difficult long-term strategy. It has the benefit of being the case that it doesn't require, it requires only winning the presidency. I think that's likely to happen. I think that, President J.D. Vance is coming. I think he has a very good chance of winning in 2028. And so this is a plausible strategy in its own right. Another strategy is to pressure Congress. And that would mean Congress passing a law, getting rid of birthright citizenship for illegal immigrants, and doing so in a way that prevents the Supreme Court from hearing appellate cases regarding those regarding citizenship questions. So Article 3, Section 2 allows Congress to strip the Supreme Court of jurisdiction on issues. It can do so. So I could very much see Congress passing a bill that that actually defines from Congress's perspective what it means to be subject to the jurisdiction of the laws in the United States, and then excludes illegal immigrants, and also in that same bill includes a provision that states the Supreme Court is not allowed to review this case. And so then you just simply take the court off the table completely. I think this should be done for all kinds of reasons. First and foremost, I think the Supreme Court has way too much power. We give them way too much credit. We offshore a lot of political decisions to this unelected body. It's terrible for the health of the republic. That's a possibility. For Congress to, that doesn't quite get to the, Congress could also go further and try and bring back the idea of explicit consent in that kind of bill. I think that's unlikely because of the 14th Amendment's discussion of birth, which brings me to the other question or the other solution, which is a constitutional amendment. And that amendment could redefine citizenship in a more fundamental way and adopt some of the principles I'm discussing here. I think if you're going to go that route, which is a difficult one, you might as well go all the way, since you're really going to have to get a grip on the core question in that way. The other possibility going forward is that President Trump could provoke a constitutional crisis by rejecting the Supreme Court's interpretation and insisting that the presidency has as much right to insist on the interpretation of the Constitution as the courts. And so the argument there that Trump could make is that the Supreme Court's judgment really only applies to the parties to the case. So Barbara, in the case Trump v. Barbara, okay, Barbara now has citizenship for her child or whatever, but all other illegal immigrants and other temporary sojourners in the United States do not get access. They all need to sue independently, and that a class suit is not legitimate. This is a pretty radical argument that I'm making here. I think there's a case for it in American law and American tradition. The idea that the branches are separate and equal, the co-equal branches would mean that the Supreme Court does not have the ability to be the final arbiter on the meaning of the Constitution. I think that's the right way of thinking. It's a lot of precedent that needs to be undone, but it is an option that Trump has. He could also, once you're in that realm of making those kinds of sweeping decisions, you're really at an almost extrajudicial, extra-legal place. Not quite, I think, in that case. But that's the next step, is to simply say, Congress has gotten this wrong. You're beginning then really from the state of nature argument. You're really abandoning the political structure, going all the way to the core issue, some kind of leader, maybe not even an elected leader, redefining, okay, we need to refound the republic from the beginning. That is a pretty extreme option, but that doesn't mean it's wrong. And I'm open to it. And I think we're just at the point where one wonders if the constitutional order itself can even survive. I mean, now you even wonder if it really has sway. I mean, it's so perverted and so disconnected from the founding principles, one wonders if it isn't just time to restart. Now, that is a radical, to go to the root of things statement, but I don't think that means it's wrong, and it's worth thinking about. I think we should keep these options on the table as we go forward. Every option here has a lot of difficulty involved. In order to get Congress to pass laws, the crucial thing that needs to be done is to repeal the filibuster procedure in the Senate, and then you need majorities to win election. You need them to be real majorities where they work together, and you then need to pass that legislation in the ways that I'm talking about and turn them into law. Right now, Trump has Republicans in both houses of Congress, but it's pretty obvious to me that he does not have the unanimity of the members of Congress to, even if you could get rid of the filibuster, I don't know if Trump could get that kind of piece of legislation through. He still has a lot of opposition from members of Congress. Now he's winning, right? He's been able to kick out some of his, more intransigent critics and force them out of power, and that's a sign of Trump's strength. But Trump only has so much time left in his term, and this is a long-term battle, and you're always going to have the Susan Collinses, at least for a long time yet. You have this problem where they have a lot of sway as these swing votes, and will they be willing to pass these pieces of legislation? And if you have a big fight over legislation in the country, what will that do on elections going forward? One possibility is that by making legislation real and really talking about a transformative legislative agenda, the outgrowth of that push could be to energize the base and to strengthen the Republican Party. If you pass popular legislation, it could redound to the benefit of the party itself and really increase its power in the long run. That's the most white-pilled take. And so there's the carrot and stick model here. As the carrot is maintaining power for the long run. The stick is losing elections because Trump or his successor is going to come down on recalcitrant and rebellious factions within the Republican Party. So that's the most likely political solution, but it is a heavy lift, and I don't think we should shy away from stating that clearly and openly. The question of constitutional amendments, of extra legal action is, I think, just a whole different world entirely. Doesn't mean it's impossible, and maybe what's needed now is a political movement that can indicate the degree to which we need to transform our regime in order to get our country back. I think there's certainly a place for that. I think the first solution should be political, and then it's only down the line that we should talk about the extra legal or the extra juridical understanding of the regime. And that's part of our tradition. The revolutionary natural rights tradition is always there, and I think we need to keep that in mind and hold it before us now more than ever. I think the deepest problems will require that we do so. And I see it in part as my job to try and clarify those problems and to use my learning and education and research and approach to problems to help my audience, you, informed citizens, policymakers. Maybe some of you are elected representatives to help you think through these problems. And if I'm doing my job correctly, then you'll have gained something from my work and research. On that note, I will conclude here by discussing some sources that might be of use to those of you who want to dig further, scholarly sources. And I haven't gone through all of these in depth, but I plan to, and maybe some of you will benefit. James H. Kettner has a book, The Development of American Citizenship, 1608 to 1870. Chapter 7 is on voluntary consent and its meaning at the time of the founding. Looks very interesting. I liked what I read so far, and compelling, worthwhile if you're interested in writing on this issue or thinking about it further. The other one is Douglas Bradburn has a book, The Citizenship Revolution, which I think is quite good, at least so far as I've encountered it. It's long; it's over 400 pages, but he gets into some of these questions, and I think there's a lot there worth digging into. So there it is. That's my attempt to deliver value, the value proposition. Here's some research. Here's a way forward. Here's hope. Right? They're just problems that need to be solved. It's the way you should look at them. Don't despair. Don't freak out. Don't indulge your emotions simply. There's a place for it. Your fire or your drive can bring you to action, but I think being demoralized is never useful or helpful. I think you just have to see these things as what they are. They're problems that need to be solved. And the way to solve problems is to use your mind. It is to think and to set aside emotion so that you can think through what it is you need to do. How do you eat an elephant? One bite at a time. It's just that simple. Just keep at it day after day. That's the answer. So with that, I'm going to bring this show to a close. I want to encourage all of you to follow me on social media, @JLippincott on X. You can follow Regime Critic, my Substack. I'm also, this show, Lippincott Talk, is on YouTube, Spotify, and Apple Podcasts. Please follow those if you want to listen. As always, I want to thank you, the listener, for giving me your time. I look forward to seeing you next time, to engaging with you on social media, to answering your questions. And overall, I'm I'm grateful. I look forward to it all. Thank you so much for listening. I'll see you next time.